I'm letting you know that you may have eaten dead flies if you ate there this past week. That was, by the way, that was a free topping. All right, has everybody got a handout? The review that was posted last night, has everybody got one?
Don't have a hard copy.
There's some.
A large copy? There's some right here.
There's some. Yeah.
And then after we go through the materials today, Dean Garrett has asked that I give you a professor evaluation. So if you'll take the time to read that.
Is this a quid pro quo?
It's not.
Really? Okay.
It's not.
What can we do to make it a quid pro quo?
Well, as it turns out, the law school won't tell me what the results are until after the final exam grades are in. And I don't think they tell me the exact name of who all made what comments.
You don't think?
I'm pretty sure they won't. Okay, anybody else come in besides Ms. Adams?
Yeah.
Okay, Ms. Adams, do you have a copy of the handout? All right, let's get started. Again, just like the midterm, it's going to be several multiple choice questions. I'm going to try to aim for 30 and one essay. And we already know about the essay. You don't write issue, the issue is. Rule, the rule is. You don't actually write issue, rule, analysis, conclusion. That's not what the bar exam is looking for. They're making sure that you know how to write in the proper legal style, which is the identifying the issue with a sentence without saying issue, the issue is. And then usually it's 4 parts to the answer: the issue, the general rule of law, the applicable facts, and then a conclusion which arises naturally from the rule and the facts. The hard part is finding out which general rule applies based on the fact pattern that you read. And if you already have guessed it from the last midterm, is that a lot of these fact patterns come right out of the cases that come out of your book. So if you're familiar with the cases in your book and the holdings on those cases, you ought to do pretty well on the exam. In the essay, as long as you can write and identify spot what the issue is, and usually that's going to be in the call of question, but not always. And then give the rule, the applicable facts, and a conclusion. Even if it's wrong, as long as you can argue it properly, then usually you'll still get credit, even on the bar exam. All right, let's start on page 252, where we picked up after the midterm. And again, we're going to cover Tribune Type 1 and Tribune Type 2 cases, or contracts. The first one, the Tribune Type 1, is fully binding preliminary agreement. But you agree to memorialize the agreement in a more formal document. And the Type 2 is dubbed a binding preliminary agreement. You agree to the major terms but leave other terms open for negotiation. Channel home centers. And I was putting page numbers on these. I missed that one. The detailed letter of intent to enter into a binding agreement creates the obligation of good faith on the parties to actually negotiate. And because it was a letter of intent, it created the obligation of good faith. PSI versus Exxon. The definition out there goes to what good faith is. It nixes trickery in certain forms of obduracy. And it does not require one to reveal all of your bargaining strategy or anything. It just says you have to have good faith. You have to negotiate actively to try to reach an agreement. That's what it requires. Then we get to section 7. First thing Section 7 mentions is it's called the requirement of definiteness. It's on page 258. First thing mentioned in there is Section 33 of the restatement. I went ahead and put that out for you in the handout. Offer must have terms that are reasonably certain. Doesn't have to be exact, but it does have to be reasonably certain. They're certain if they provide a reasonable basis for determining the existence of a breach and for giving a remedy. And then one or more terms may show an intent of not being an offer or an acceptance. Remember the mirror image rule from last semester, earlier this semester? That in order to be an acceptance, it has to mirror the offer, it can't change any. Well, if you put in something that's ambiguous, says we'll continue to negotiate about this, can there be an acceptance on it? If they say, yeah, we accept this, we'll continue to negotiate. You haven't made an agreement yet, have you? That's what they're talking about on indefiniteness. The court can consider negotiations, communications, external sources such as government regulations and applicable trade usages. That's the intro to the entire chapter, right? Or the entire section. Just to let you know that we're going to talk about those things again throughout the rest of that section. So Toys Inc. renegotiate at the then prevailing market rate. First thing that case pointed out was the fact that you're not actually renegotiating anything, are you? You've already agreed that you're going to rent at the then prevailing market rate. They just don't know what that rate is, but it's reasonably easy to ascertain what that was, right? So if you put a term, we'll renegotiate at the then prevailing market rate, you've already committed yourself, right? A party who has, in the course of performing an agreement that is unenforceable for indefiniteness, that's conferred a benefit on the other party, is entitled to restitution. Yay! That's that first 150 pages, isn't it? Yeah. So you get back what you put into it, or at least the cash equivalent of it. Indefiniteness of contractual incomplete and contractual incompleteness. There's UCC 2-311. If you haven't read that yet, go and read it. It's there to remind you to read it. Contracts are incomplete in two different senses. Relevant terms may simply be absent, leaving gaps in the contract. Courts use gap fillers to fill in those terms, right? Under the UCC they do. And then if it is insensitive to relevant future contingencies, boy, that's the key to it all. How much do you have to put into a contract for it to be complete? Well, it needs to cover things that might actually happen, not things that could never possibly happen. I mean, yes, the world may come to an end. We may all have our final day of judgment. Do you need to put that in your contract? That's not something you would expect to arise in the performance of the contract. That's what they're talking about, is it's got to be relevant to the contract. If there are things that can happen that are relevant to the contract, such as you're buying something out of the Middle East, and then a war breaks out between Israel and who knows who, and that affects your supply chain, do you think you might want to put that in? That if war breaks out in the Middle East, that the contract's put on hold?
Yes.
Yeah.
You might, particularly when the tensions over there are escalating, right? So relevant means something that you would expect to happen during the course of the contract. Relational contracting, only thing I got out of that is that usually when you're repeat players, you've dealt with somebody a long time, you don't usually put all the terms of your contract in it. It's just assumed by your previous dealings that this is going to be the same type of agreement. Now, is it reasonable to assume, if you've dealt with them a lot, that this is going to be part of your agreement?
Yes.
The answer is yes, because later in this chapter we find out that course of dealings is relevant to establish terms of a contract, right? So they introduce you to the fact that you have repeat players and kind of suggested that course of dealing, which is covered later. Indefiniteness and contract price. Well, the UCC, again, provides all your gap fillers, right? Reasonable price at the time of delivery. There's 2-305, the open price term. And then they introduced you to a whole bunch of different clauses that people use for contracts, such as an escalator clause, tied in some way to the market. It also happens, an escalator clause is like a commercial lease, where they'll give you a good deal to get in at $10 a square foot for a year, and then it goes up to $11 a square foot per year the next year, and then the year following goes up to $12 a square foot. That's where they get your foot in the door for a good price, and then they continually increase the price of your lease. Cost plus contracts, that was a government contract reference to it. Whatever it costs you, plus you get a certain amount on top of that, that amount or percentage is usually negotiated. For government contracts, it usually includes a percentage of profit and a percentage for your general administrative expenses. Most favored nation, that's when you're dealing with international business. Who's a most favored nation?
A rich one.
A rich one? Almost.
Trade partners?
Yeah, trade partners. Remember NAFTA? It's been renegotiated at this point, at least half of it, with Mexico. They want to be a most favored nation, so they get the best rates. And then the last one, most favored counterparty. Again, that's going to be like in government contracting. The government wants to have the status of the most favored vendor so that they're guaranteed to get the lowest price. That you don't charge higher prices to the government than you do for your best customer. All right, statute of frauds, Oglebay. The adequate shipping capacity for iron ore across the Great Lakes. Remember what happened on that case? The shipping company had to make sure that there was so much room, but then the ore company didn't use it all. So there was a breach. And then section 362 on restatements. By the way, if it's just a section number in here, it's a restatement section number. If it's a UCC, I put UCC in front of it. That'll help you go back and look those up in this book to make sure that you've gotten everything covered. All right, statute of frauds. Probably one of the most important things that we've studied this semester. Because for a statute of frauds, if it's not in writing, then it's not enforceable, right? With a few exceptions, it's got to be in writing, and it's got to be in writing under certain circumstances. I put for you the original 6 times where statute of frauds requires it to be in writing, and those are pretty consistent later on through, except for where United Kingdom actually threw that out. The United States still uses the statute of frauds. Executor administrator provisions. To answer for the debt of somebody else that you're administering their estate. Contract to answer for debts of another, that's the suretyship provision. Contract made upon consideration of marriage is the marriage provision. Contract for the sale of an interest in land is the land contract. Now, what is the sale of an interest of land? Well, yeah, it's real property, but what kind of interest do you have for land? Well, you got title, number one, right? That's who owns it. Use, I heard use, that's who gets to use it. Now, is that exclusive? Like rent? You have the right to exclusive use and quiet enjoyment and possession of the property? That's one. How about another use such as an easement? Like the utility company has the right to put power lines over part of your property so that you can get power to your property. So it's all those different interests. It's not just ownership, it's everything else too. The 1 year provision where the contract has to be performed within a year. Remember, the courts don't like that provision anymore, and they'll find a way to get around it. And then the last one is the sale of goods, which of course is covered by the UCC. And as we know, not everything has to be in writing because the UCC provides your gap fillers. All right, so what does the statute of fraud do and not do? The starting point is to see whether or not there's a contract at all. And then the second one is it has to be in writing in order to be enforceable. They say there's a term of art that's actually included with it. It says whether the contract is within the statute of frauds, meaning is it one of the categories which requires a writing? And then if it's within it, then it has to have a writing. And if it does, it satisfies the statute of frauds. So your two tests are, does it come within the requirements of having to have a writing? And then does the writing actually satisfy the requirement? Exceptions to the statute of frauds. With every good rule, there's an exception. Reliance, part performance, and admitting that the contract exists. That's the most fun one right there, is when somebody comes into court and says there's no contract at all, and then you get them up on the witness stand and you say, well, isn't it true that this is what y'all did? No, that's not what we agreed to. Ah, you had an agreement. That's admitting that there's a contract. So that's an opportunity for your aha moments. All right, background, no useful info. I don't want to just put stuff in there for you that's not useful. So why do you have a statute of frauds? This is the three functions I told you about. Number one is your evidentiary function to prove that the parties had in fact made a contract. Your cautionary function so that you think before you sign. And then your channeling function, you put all the terms in there that you really want so that the court can tell what your promise is and that it's enforceable. Now, the reason that that section is important is that when you see people, and the courts in particular, go in and challenge whether or not the statute of frauds ought to apply in these cases, what do you see them discussing? Circumstances, whether or not you need to have evidence of a contract, such as a writing is going to be proof better than your memory from more than a year ago, right? So that's one of the instances that they will say it serves an evidentiary function to have a writing because it's better than memories which fade. And then the cautionary function about signing it. Remember, there was a provision in one of your cases that says you're presumed to have read a contract before you signed it. That's that function, that you won't sign anything before you read it. By the way, how many of y'all sign stuff before you read it? Do you know what you've agreed to do?
No, absolutely.
That's why you read it before you sign it. Those of you who've been to a car dealership and bought a car, how many of you have honestly read that contract before you signed it? Me too.
I did so far, so I know what they put in there.
When I think of unread things, I think of like all the things that people get with acts and those user agreements. That's what I think of that people don't read.
That's true. How many of you have actually read Google's terms of service? I hadn't read that one either. All right, so the next one, Section 2, the scope. Duration of performance. Here's where they don't like the 1 year contract. Here's what you got to know about it. The 1 year provision runs from the time you make the contract to the time of complete performance. It's not from the time you start the contract to when you finish. It's from the time you make the contract to the time that it's finished. That may be a subtle distinction, but here's the example of how it can go wrong. If you make the contract and the contractor starts the next day, that's pretty simple, right? But what if you make the contract and it's months later before they start? Is that okay?
No, that happened with our house because of rain.
Well, it's okay as long as it doesn't take them that long to finish the contract, right? If they wait for months and it only takes a day to finish, that's okay. But what if it takes them half a year to finish, and they've waited 7 months before they start?
Over a year, that's a year and 2 months, 3 months.
Yeah, it does. It goes squarely outside, and that's from the time you make the contract, right? Not the time that they start.
Like
All right.
Start making the contract or sign
Yeah,
it?
can you say
Like
that?
sign it?
It's from the time of contracting. It's when you sign the contract.
Sign it, okay.
Yeah.
Because
Well,
you can
make-
take a lot of time to make a contract, too.
Well, the making actually is the culmination of signatures. That's the actual making of the contract. All the rest of that's negotiation.
Okay.
So it's from the signatures to the completion, 1 year.
Right. If it's more than a year, it has to be in writing. If you have an oral agreement, yeah, I'll build your house for you, and you don't specify a start time or a stop time, and then it goes outside a year, then that's not going to be enforceable if it takes more than a year. That's your statute of frauds requirement. Such as the construction contract at University of Connecticut, made with a handshake and a "we've got a deal." That's where they actually said that the 1 year provision is disfavored by the courts. They actually held that the oral contract does not say in express terms that the performance is to have a specific duration beyond a year, and that's the functional equivalent of a contract of indefinite duration for the purpose of the statute of frauds. So is it a contract? If you don't specify how long it's going to take?
No, because time is one of the requirements.
That's the trick part of it. Is there an agreement to start with? Yes. They're going to build buildings at the University of Connecticut, right? Does it fall inside the statute of frauds? Is it within the statute of frauds? Is it for building something on land?
Real estate, so yeah,
Yeah. So does it have to be in writing?
yes.
Yes. So that's where they messed up.
What if it took less than a year?
Well, if it took less than a year, then they didn't mess up on it under the 1 year provision.
Right.
But just because it doesn't mess up under the 1 year provision doesn't mean it doesn't mess up under another provision. Remember the list of within the statute of frauds? It can be within it under several different provisions. If you're guaranteeing that the building will be built by somebody else, and it takes more than a year, then you've got 3 different provisions, right? You've got a guarantee, a year, and then the sale of land or something affixed to the land, and interest in it. All right, informal extensions of employment. Folks, if you haven't learned anything else in contracts, is that employment in Alabama is what? At will. So, do people have written contracts for employment? Not usually. And when you have an informal, do you have really anything that's enforceable?
No.
No. Now, if you have a writing to back it up, like the guy did on whatever that salesman position was, yeah, Elizabeth Arden, with a writing on it, then it is enforceable. But the informal ones are difficult to enforce. Yes. Somebody raise their hand. All right, how about lifetime agreements? I will work here till the day I die.
Back page 1.
Page 288. I did start putting page numbers in them, by the way. That way I didn't want to get lost. So if it helps you out, that's good. So what about I'll work here to the day I die? Does that violate the 1 year provision? Not if you die within a year, right? If you die outside of a year, does it violate it?
Yes.
That's the tricky part. Contract for lifetime employment is not subject to the statute of frauds because it may be performed within 1 year if you happen to die. Interest in real property, restatement section 125. That's at the bottom of the next page. For the sale of land, what is an interest in land? Page 291, there's 127 of the restatements. Plus, it does mention right-of-ways, mortgages, and leases. just so I know that everybody in here is on the right track. What exactly is a right-of-way?
Like an easement?
Well, a right-of-way is a little different from an easement, but it's basically the same. They have the right to go across your property,
I was
right?
gonna say, that way you can cross to get somewhere.
Have any of y'all ever been out to railroad tracks? Anybody? You see those big old signs that says ROW? It's a marker for right-of-way. They don't want you to actually row across the railroad tracks. It's the right-of-way. They're telling you where it is. All right, the next one is mortgage. All right, how many of you are homeowners? And you signed away that mortgage, right? Who owns your house? Literally, who's the title with?
The loan.
Mortgage holder.
The one who mortgages the property, right? You, who signed a mortgage to the bank. The title's actually in your name. So what exactly is a mortgage? It's the right to come back and take it away from you if you don't make payments, right? In plain words, that's what it is. It's a promise for you to pay back the bank so much money, and they will release the encumbrance that they have on your property. So technically, yes, you do own it, but you owe the bank a lot of money. But as soon as that's paid off, they release the mortgage. All right, suretyships. A suretyship contract makes one person liable for the obligation of another. We talked about co-signers. How many of y'all have co-signed a note for your children?
None old enough.
Don't ever do it. Co-signing a note with your children means you're going to end up paying it. Now, for those of you, Ms. Willis, you raised your hand. Are you paying it?
Not right now.
Great answer, because eventually she probably will. All right, the next one is bail bondsman. If I did not tell you this, how bail bonds works, when you go to jail, except as an attorney to visit your client, when you go to jail and they want to release you, your promise is that you're going to pay so much money to the court if you don't come back. That's what a bond is. Now, how many of you can afford to post a $30,000 bond when you get to jail? You get a bond company, right? You give them about $3,000 and then they will come sign paper for you to get out. That signature that the bondsman make is a promise to pay the $30,000 if you don't come back to court. So that's how it's a promise to pay for the debt of another. It's your debt getting out, but they're promising to pay it if you don't show back up. That's how it's a debt for another.
They sent the dog after.
Is what?
They send the dog after you, the TV show.
Yeah, Dog the Bounty Hunter. Except when he's arrested for domestic violence, right?
Clarify the surety agreements where, like, if there was a husband and wife, and the husband's not a co-signer, the wife's not a co-signer, but one of the parties will default, how are they able to come, do they come after the estate or the?
Wait a minute, somebody died?
No, not even someone died, but do they come after the money that's commingled then? Because one of the parties, like, how does that work?
Well, it's complicated. Everybody who owns the property, if it's marital property, they both have a claim for an exemption up to a certain amount. And it's either $5,000 or $10,000 now. I think it's 10.
You don't list.
So what they'll do is they'll sell your home, they'll give you the first $10,000, and then whatever's left from the sale they can use to get their whatever money they're owed.
So if your significant other defaults on something, you should still be held responsible without having a surety as a co-signer.
No, you get your exemption back out of it, but you're out of your home.
Okay.
The parties to the suretyship are the surety and the principal. The principal is the one who originally owes the debt, and the surety is the one who's promising to pay it in case the principal doesn't do what they're supposed to. Now, the next section is probably one of the more important ones for you to understand. and the difference between a suretyship and a guarantee. A surety is normally jointly and severally liable with the principal. What that means is they can come after either you or the principal, the surety or the principal. Jointly and severally means they don't have to take any other steps first. They can come after whoever's got the money. However, a guarantor normally agrees to fulfill the principal's obligations only after the principal has failed to do so. What that means is that they have to sue the principal first, and if they can't collect their money, then they can sue you. So from your perspective, is it better to be a surety or a guarantor? A guarantor. Ms. Willis, I know why you came to law school. The next part that was hidden in there is if the surety is taking the place of the principal rather than merely agreeing that the principal will perform. If you're substituting one principal for another, that's called a novation. That's a new contract, by the way.
And they would just buy out.
They buy out the obligation. And in fact, that's what happened in the next case, Langman versus Alumni Association with the University of Virginia. They deeded a piece of property. It was the game room, right? That was the game room?
Yes.
They gave the game room with the mortgage to the university. So who owes the money for the mortgage? The university does. You give a piece of property that's subject to a mortgage, they take it subject to the mortgage. And then they say a grantee who accepts a deed becomes contractually bound by its provisions and becomes liable to perform any promises. Well, that long language just means they have to pay the mortgage. You take it subject to a mortgage, you pay the mortgage. A grantee who assumes an existing mortgage is not a surety. They're a principal, right? It is an original undertaking, not a derivative one. And why they just don't use plain English in these, I don't know, but the essential part of it is you become the one that's on the hook, not as a surety or guarantor. You are the principal. So if you haven't picked up yet, you need to know the difference between a surety, a guarantor, and a principal.
So would that be like if, let me see if we can get my example right. How you can, people say things like someone's going to take over the payments for a car. So you're just switching.
And they give you a bill of sale for the car, but it has a car payment due on it.
Right.
Who owes the money now?
Whoever took it on.
Yep.
So that's the guarantee.
No, that's a novation.
That's the novation.
Because you are the new principal.
So if I don't want to pay any more car payments, I can just sell to somebody?
Well, they become responsible for the obligation, but then the bank turns around and sues you for not making all the payments. Yeah.
Does that happen with firms that will buy, like, the bad debt, they become the new guarantors?
Like sell your mortgage?
Like credit card debt.
Like any debt, you know how people make money off buying people's default?
They try to.
They try to. But when they change those contracts, they would become the new grantor. Yeah.
Okay. If I haven't told, let me give you this example because this is a great one. I had a client that owed credit card money and hadn't paid it. And so the credit card company sold the debt to somebody else. That's what you're talking about, right?
Right.
So when they sold it to that other financial organization, they filed a lawsuit for breach of contract.
The client did or the new?
The new owner of the debt, the new owner of the money that's supposed to be paid on the debt, filed a lawsuit against my client. And then my client comes to me and says, I'm being sued, can you help me out? Well, now, they now own the right to collect the money, and my client owes the money still, right?
Right. I think so.
And since it's become uncollectible, the original owner of the right to collect the money sold it to somebody else for pennies on the dollar because they think it's uncollectible. So they're getting out whatever share that they can get, selling the entire right to collect the debt over to somebody else. So they filed a lawsuit against what was soon, right after that, to be my client. So we had court. I filed an answer denying everything. We had court. And on my way to court, I thought, let me call my client. Because remember, if there's a contract, if they put my client on the stand and she admits it, then it's over, right? So I called my client up on the way driving into the courthouse. And I said, tell you what, our court hearings are up on the 6th floor. I want you to go sit in the hallway down on the 4th floor. And just wait for me to come find you. Fine. Client goes to the 4th floor and sits and is waiting. I get to the court on the 6th floor and I'm talking with the attorney who's trying to collect the money and saying, can we reach a deal? We'll pay this much if you'll accept that much and we'll get rid of the rest of the debt. Fine, that sounds like a fair settlement to me, but let me call the original attorney and run that past them to see if they'll agree to it. So she got on the phone and called the attorney down in Montgomery. The attorney in Montgomery said, no, we got to have it all. So she hung up the phone and came back and said, we don't have a deal. And I said, okay, call your first witness. She didn't have anybody there. So she looked around the courtroom for my client. She said, I don't see your client. No, you don't. So the judge calls the case and tells the plaintiff to call their first witness. Judge, I don't have a witness. Okay, judgment for the defendant. So I take that piece of paper down to my client on the 4th floor and say, that money that they sued you for, you don't owe a penny of it. Now that wouldn't have worked. That wouldn't have worked if they had my client under subpoena because that's court order to appear. But they didn't have my client under subpoena. My client wasn't under any court order to be there. So while some people may buy the debts of another, it's still their duty to prove it. That's the civil procedure part of it. You raise it, you prove it, right? And since they were unable to prove it and didn't have the opportunity to put my client on the stand to admit that, yes, that was her credit card, she owed money, then they failed their burden of proof when you win.
And so this section, so it would have to be in the very original contract somewhere that they would be able to sell the debt down the road if they defaulted.
And they almost always all put them in there.
And then the new person or bank buys the debt, becomes the grantor.
And they send a letter to your client that says, please continue to make your payments, but mail them to this address instead of the original because we bought your debt.
Okay. And then usually they end up in court like that.
I won't say always,
Okay.
but then they have to show up and then they have to have the original loan paperwork showing, yes, my client actually signed this. They didn't have the paperwork, they didn't have my client.
So if we saw this on an exam question and it had like a transfer, you know.
I'll tell you what, that's too complicated a question to have on contracts.
Okay.
However, when you take UCC, that might be a good question to put on UCC.
Okay.
And it's going to be on negotiable instruments rather than just sales.
Okay.
Everybody got that?
I won't worry about it.
For that,
Yeah, don't worry about that for this exam.
just out of curiosity, why would, in that case you were just talking about,
Mhm.
why would they not issue a subpoena for your client?
Because you don't ordinarily subpoena parties. You subpoena non-parties.
They were just assuming she was going to be there.
They assumed.
Do you take interns?
Not usually.
What about unpaid interns? Just people I hang out with.
Yeah, just let
Yes,
us follow
ma'am.
you around and take
I'll tell you
notes.
jokes.
I just wanted to clarify, have kind of a question on the novation. So, the novation can come out of the surety taking the place of the principal. Can a novation come out of a grantee also?
Well, the thing about a novation is that you're getting somebody new on the hook. Do you have a surety on the hook? Yes, they're already jointly and severally liable. So a surety is not likely to become the principal because they're already on the hook. Now, can you get a guarantor on the hook as a principal rather than somebody you've got to wait after you try to sue the principal first and you can't do it, then you sue them? can you try to get them on the hook originally? Yes. And if you can get them to sign a piece of paper that says, I'll no longer be a guarantor, but I'll be a principal, that I'll pay this anyway, you got to have that in writing because it's answering for the debt of another.
So when it says a grantee who assumes an existing mortgage, so in that case, the grantee is not a novation, it is not a new contract.
It's not a new contract. They become the principal because of the transfer of the property subject to the mortgage.
Okay.
The tricky part on that is there wasn't a contract, it was a deed.
Oh, okay.
But the deed assumed the obligation, and that was all done without a contract. It was a gift to the university, right?
Right.
So just because you assume an obligation doesn't mean it always has to come through a contract. That one was a deed. All right, the main purpose rule on 295. It's a three-part test, or three circumstances. The party is indebted, there's no novation, and the third party's duty to the creditor will be terminated by the performance of the promise by the defendant. And then restatement section 116. On page 299, kind of sets it out that litigation lawyers or litigators have the facts come to them as they are. They have to actually litigate whatever comes to them. Transactional lawyers try to avoid that. So when a transactional lawyer is hired to draft up a contract, they're wanting to do everything to avoid having to go to a litigator. And it's only when the transactional lawyer forgets something which is relevant, where the contract becomes ambiguous, or any other of those circumstances does it have to go to a litigator. All right, so the contents of a writing, 4 things that it should have. The section is called Who, What, and Whether, but it actually has 4 things that are required for reasonable certainty. The parties, the fact that they made a contract, what the contract is about, and the essential terms of the contract. The exception of that is land sales contracts, where you have to describe the land clearly enough. It's gotten to the point now where most everybody puts a legal description in it. However, you don't necessarily have to put a legal description if you put the street address. If I want to sell you 123 Main Street, is that good enough?
Yes. Well, as long as you put the city and state.
That was the trick. 123 Main Street in Birmingham, Alabama. That's pretty specific, right? 123 Main Street without a city and state. If y'all have seen those new Allstate commercials, Main Street in one state doesn't look like Main Street in the other. All right, so stating the essential terms, section 131, it depends on the circumstances. They also talk about the 4 functions to be achieved, or the 3 functions, evidentiary, channeling, and cautionary. But the essential terms, depending on the circumstances, what do you think might happen out of the performance of the contract? And so you need to address each of the circumstances of things that could happen, not the obscure. You know, don't put in there if Martians come and take away the person who's to perform the contract. Is that likely to happen? That's likely to get commitment papers drawn up against you. All right, the 4 corners. They finally introduced that term on page 301. And the 4 corners actually is going to go in a whole lot of greater detail when you start looking at parole evidence and whether or not the contract's ambiguous or not. Read whatever is on the paper, because that's supposed to be the best evidence of what the parties agreed to. The issues as to form, well, a letter, a receipt, a check, a price list, minutes of a meeting, and a will. How about a note on a bar napkin? Yes. They forgot that example in your book, even though they gave the case on it, right?
Got Alabama on probation with Antonio Lane. They did.
Yes, it did. Oh, there's Crabtree versus Elizabeth Arden. The internal company memo was used against the company. Remember that? They sent the note to payroll that says, pay this guy this much for this long and then change his pay to this. Even though it wasn't signed by the parties, it was drafted up by one of the parties, right? Remember the expression that says, whoever drafted it, it's to be construed against them? That's also later in your case. So parole evidence. What is parole evidence?
Anything that you bring in outside of the contract.
That's it. It's anything outside the four corners that you bring in to explain what the contract is. Anything. Can it be whatever you talked about? Yes. Can it be emails you exchange back and forth? Yes.
I thought parole was an oral subcategory of extrinsic.
Oral is part of it. Also, physical evidence. It's any extrinsic. Extrinsic is anything outside the four corners. So yes, that answer is still correct. It's just that oral and emails and conversations being the oral, everything outside the four corners that's used to explain what the agreement is.
Both parties have to be aware of it. For example, if you recorded a conversation, they didn't know you were recording.
That's an evidence problem. In Alabama, both parties don't have to know they're being recorded, by the way.
I think that is crazy. Because parents record meetings all the time and like you never know.
You just assume they're being
Just don't say anything you're not supposed to.
Well, then they try to lead you. They're like, are you saying my kid is ADD? Exactly.
Maybe.
He's 50. I can't say that. That's illegal. So I'm not doing.
I'm not saying that, you did.
That is exactly what I'm going to use next time. Oh, you said that. You said that.
All right. UCC sections 1-201 about the signings. Remember, it's supposed to be signed by the party against whom you're holding the contract against. So is it important to have both parties sign a contract? Yes, so it's enforceable as against each party.
Oh, I thought you meant if only one, the person who's getting forced against signed it, then it's...
No, if the two parties sign the agreement, is it enforceable against the buyer? Yes. Is it enforceable against the seller? Yes.
But if one person signed it, it's enforceable against the person that signed it.
Now we're getting there. So what if the seller drafts up the agreement and only the buyer signs it? Is it enforceable against both parties?
Yes.
Yes, because they drafted up the paper, right?
Yes.
So it is enough that it's drafted up on their letterhead, which was the Elizabeth Arden case. Even though they didn't sign it, they drafted it, so it was held against them.
What if it's
So-
not on their letterhead? Like if it was just,
If there's testimony as to who drafted up the agreement,
so you would have to get them to admit that they did it.
or you testify yourself that I saw them sit there and write it up themselves. And if they don't deny that they wrote it up, you get a handwriting expert in. Is this their handwriting? Then they're kind of stuck. We talked about the digital age. I put the reverse preemption of provision in there because I don't care about reverse preemption of provisions. What I do care about is the fact that you know what preemption is. And preemption is where federal law controls state law. So if I have a state law and a federal law that talk to the same issue, which one is going to control? Federal, and that's because of the supremacy clause of the U.S. Constitution. It says federal law trumps state law. So the reverse preemption, if federal law preempts state law, what is a reverse preemption? It's where federal law says state law will control.
So they can only take it when federal gives it.
Yes. Whenever the federal says the state law will control in these circumstances, that's called a reverse preemption, and it it will state law to control.
But you're saying you don't care about that, you only care about preemption.
The fact that you know what preemption is.
Your example was the Roe v. Wade and the clause in at the end of the state law.
That was an example I gave in class about where the federal court said if state law grants rights,
Right. That would work with it.
and by the way, Alabama has now granted those rights. The rights to unborn children. Did everybody make it for that class?
Yeah.
Now, my experience with that is it's probably going to upset half of you and the other half are going to be happy about it. I'm just here to tell you what the law is.
I just care about
The Uniform Electronic Transactions Act, the UETA, if the law requires a writing, an electronic record satisfies the law. So what is an electronic record?
Validated.
Anything, isn't it? Is it an email which evidences the fact that there's something there? Maybe an agreement? Then an email is going to be good enough. And if the law requires a signature, an electronic signature satisfies the law. Well, I'll tell you this. Alabama now has electronic filing, and they've specified the exact form an electronic signature needs to take in order to be an electronic signature. So if a pleading has to be signed by a party or their attorney, and you have an e-signature spelled out according to how the court says you got to have one, is that going to be good enough to be a signature on your paper? The answer is yes. The exceptions of the electronic signatures is wills and trusts. Those are specifically exempted out. Why do you think they want wills to have an original signature rather than an e-signature?
Because people make up a lot of things after somebody's dead.
Let me tell you about this friend of mine.
Doesn't it have to be witnessed?
Yes, by the way. If you're going to have a self-executing will in Alabama, it's got to be witnessed by two people and notarized. Can you do all that with electronic signatures? So let me tell you about this friend of mine. Her uncle died. Guess what happened when the uncle died?
He had a lot of money.
A will surface.
He had a little bit. Yeah, he had a will. He said he gives whatever is in his estate to his children. So what do you think happened?
They fight over who gets what.
3 people showed up and said, he was my daddy. 3 people.
Dana.
And you know what? They really were. That was in Coleman County, by the way. Just if anybody's curious. The statute of frauds in the sale of goods, UCC 2-201 says if you're selling at $500 or more, so it includes $500, you got to have a writing. Can it be electronic? Yes. Yes.
On the will thing, if children don't get along, is it just easier for the courts if the parent dies without a will or if they die with a will? Like, what is easier to be sorted?
It's easier if they have a will. Because if they don't have a will, it's intestate, and the circumstances on it are that they're going to divide it equally, but how do you divide equal? If it's a piece of property, who do you give the better half of the property to?
Liquidate it.
Maybe liquidate it, but what if that property's been in the family for 100 years?
And they should have made sure daddy got a will.
See, that's it. So, even though this is not part of your contracts, what I've been doing lately in my wills is putting a provision in that says the children have up to 60 days to decide how they want to do it. And if they can't reach an agreement in 60 days, then the personal representative will decide for them.
Who's the first person?
Whoever I appoint to handle my estate.
Oh, okay.
So, you think that's a good way to handle it?
Yes.
Gives them 60 days. They got to get off their butts and make an agreement, or otherwise they're going to have to settle for whatever they get. Yes.
The purpose of the notarization, is that just to identify who they are, or is that to avoid, or Like, why even do it?
All right, you're getting into wills.
I know.
I'll tell you this.
Don't worry about it for this class.
Yeah, don't worry about it for this class, but when you sign a will, at minimum you have to have 2 witnesses. And they both have to be where they can see you and hear you say, this is my will that I'm signing. They both have to be there. It's been litigated where somebody was across the street with a pair of binoculars looking as they signed it, but they couldn't hear them. That wasn't good enough. You have to be where you can hear and see them. And then
Stalker? Case of witness?
No.
I want to read that.
a recluse was signing it and they didn't want anybody in the room with them. And then the notary, if you just have 2 witnesses, then when you die, you're going to have a hearing on whether or not it's your will, and you've got to find at least one of those witnesses to come and testify that this was your will. I've run into that situation where we had to send a commission to somebody out in Texas to take the testimony of one of the witnesses because they moved away.
Just for identification purposes in,
Yes,
okay.
for the fact that it was their will. Now, adding the notary on top of it to make it self-proving, the Alabama legislature has said, if you'll not only have these 2 witnesses, but a notary who identifies both witnesses to make sure they're who they are, and everybody's in the same room as the testator who signs the will, then we will relieve you from having to have a hearing to have it admitted. It will automatically be admitted. That's what self-proving is.
Does that transfer to real estate contracts to you guys?
No, just wills.
Just,
What about those like surprise video wills that always popped up in like 1980s movies?
In Alabama, they're not valid. And holographic wills, where somebody handwrites out their own will, those aren't valid in Alabama either.
Oh my gosh.
If you want to have it valid, you got to follow the law. Otherwise, it's going to be up to how the state wants to give it out. And oh, by the way, there's a state law that says if there's not the relatives that we want you to send the property to, according to state law, if we don't have any of those relatives, then guess who gets the property? The state. It's called an escheat. Escheat. E-S-C-H-E-A-T. Cheat is actually in there. All right, so let's get back to our review. 2 types of reliance, performance and estoppel. And remember, there's part performance and full performance. There's a term for only part performance. They didn't bring it up in here, but you need to know this term for part performance, and that means that part of the contract is still executory.
You said 4.
Y'all remember reading that in your... Right. But if it has not been fully performed, then it's still executory because something still has to be done on it. If it's full performance, then it's no longer executory. Can you renegotiate those? Not without new consideration, right? We're coming to that. Just remember the executory is part performance. And then 2 exceptions on that. Dealing with merchants, you don't get reliance if you're a merchant. And then you don't get reliance if you admit that there's a contract.
And send them to the fourth floor.
And that's on page 312 in your book. The reliance-based exceptions, part performance except for suretyships. 2-201, the exceptions for the sale of goods. If they're specially manufactured for somebody, you can't get out of it. You still got to buy whatever it is you put a special order in for. They cannot be sold to others in the ordinary course of business. And the seller has substantially begun making the goods or commitments to get the goods. Let me...
Etsy falls under the UCC.
Yeah, that does fall under the UCC. Let's talk about an example on this one. What if I have a sign maker and I want the sign maker to make me a whole bunch of signs for my real estate company that says for sale? Everybody with me? Now, what if they've started working on that and I decide I don't want that, I want to go somewhere else?
It's just for sale.
It just says for sale, right? They can sell it to somebody else. Now, what if it's, I'm running for judge and I want the sign to say Bodie for judge?
Then it's custom, you gotta pay for it.
That's pretty custom, isn't it? Can I sell it to somebody else in the ordinary course of business? Not unless their name's Bodie, right? And not unless they're running for judge. Now, how about, let's use an example out in Utah. There's a whole bunch of Smiths out in Utah. That just happens to be a frequent name out there. How about Smith for judge?
Like, how do you define, like, how, what's the scope of ordinary business here? Like, how much effort do they have to make to resell this?
It's whatever you can convince the judge of.
And what if they haven't started making it, but they say that they have?
But they've started ordering supplies for it?
Okay.
Are the supplies where they can use it for any other customer?
Yep.
They still are, right? So that's the one exception about the sale of goods. Section 129 of the restatement. Then Beaver versus Bromo. Oral agreement to sell land. This is the guy who worked on the horse farm, right? And they said, "Ooh, we got you a piece of property, you can build you a house." So he takes out his 401k, his IRA, start building a nice house. But he wasn't happy, so he went to work for the competitor. Did the court let him have his house, even though it was for the sale of land and they didn't have a writing?
I think so, yeah.
They absolutely did. That was his reliance on the oral agreement. All right, estoppel on page 322, it mentions sections 90 and 139. Monarcho, that's where they promised, if you stay here and work the farm, we'll give it to you in our will. And they stayed and worked for several years, and then somebody changed their will. Do they get to override the will because they've already performed?
Yes, they gave up so much.
They gave up so much. So that falls under equitable estoppel. It wouldn't be fair to let them get the benefit of all that service and not uphold their end of the bargain. That's equitable estoppel. They also used a method called a constructive trust. You'll learn about that more in your equity class, where I'll give you the example I give in my civil procedure for constructive trust. Let's say I've got somebody who's a soldier. How many of you have actually served in the military? Okay, any of you served overseas? All right, let's use this example. We've got a service member who goes overseas, who's assigned to go overseas, but then all of a sudden they didn't want to lose out on their fiancee, because remember that song, if you like it, you better do what?
Put a ring on it.
Put a ring on it? So they put a ring on it, put a ring on that finger, and while they were overseas, they said, you know, we're going to need a place to live together. Yeah, we are. And start our family. Yeah, we are. Let me start sending you some money. You can save up and pick your dream home. And we'll go ahead and buy it while I'm overseas so that we can start our family when I get home. So he starts sending money home.
Jody says thank you.
And she decides, you know, it's kind of lonely here without you here. It's been months.
Good old Jody comes.
So they go and find him a boyfriend, and when they buy that house, they put it in her name because she's the only one there to sign the deed, right?
They weren't married yet?
Not yet.
Okay.
Not yet. All he did was put a ring on it. So he sends money home, she buys the property, puts it in her name, and then moves in with her new boyfriend.
Did you have it in writing?
Service member comes home and finds her and new boyfriend in the house that he bought. It was his money. All right, so what do you do for a remedy in that situation?
Give him the house.
Smith and Wesson.
I heard Smith and Wesson.
Apply the firm of Smith and Wesson.
All right, when you go to court and you show that it's actually your money that paid for it and that they had no money that they put in on it, the court will actually create something called a constructive trust and put the homeowner as the trustee and order that trustee to convey that property over back to the service member. The constructive trust puts that person under the responsibility of the court and puts that property into the trust, and then orders them to convey that property over to the true owner. So you're not without a remedy, but it is an equitable remedy called a constructive trust.
That example, they didn't get married, they only were engaged.
They were only engaged. Once they're married, it's marital property, and then the court divides it up. Right?
And the ring had nothing to do with it.
Ring had nothing to do with it.
He can get that back
Does he get that back too? He should.
Is that a promise for consideration of marriage? That's next semester. And the answer is, if she breached the agreement to get married, he should get the ring back too. That actually is something you learn in your domestic relations class. All right, so let's keep moving. Estoppel on page 326, the minority view replaces estoppel or displaces it. That's the minority view. So what's the majority view? Estoppel is still available, right? That's what you need to know for the bar exam, is the majority view is that you still have estoppel. All right, UCC and the sounds of silence. St. Asgar Mills versus Street. That's your corn futures case. Somebody promised to buy so much corn from a distributor, and then when the price went up, they decided not to. Wasn't that it? Because they could buy it cheaper from somebody else?
Yeah.
I guess the price went down and they decided to get out of this contract. Bless you. Now, can they get out of the contract? No, they cannot get out of the contract. All right, UCC, judicial admissions exception. Where you admit it, that there is a contract in your pleading testimony or otherwise, the court will accept the fact that you've admitted there's a contract and they will impose a contract. Period. Section 6, assessing the statute of frauds. The policing the bargaining process, the introductory part of it says they're going to look at the status of the parties, the behavior of the parties, and then the substance of the bargain. So, first thing, capacity of the parties. Minors, mental infirmity, and coverture. Boy, that was a good class, wasn't it? Y'all learned that married women lose their rights. Used to. That has now been abolished. And it was based on the old biblical principle with when a man takes a wife, they become one, right? And then you had to sue the husband if it was the wife's breach. We got rid of that. So coverture is no longer a prohibition against suing a married woman.
Let the man get sued. Leave me out of that.
All right, so at least some of your classmates want to go back to the olden days. Just remember, that's back before women's suffrage too, though.
Oh, no, we still want that.
All right. The first case on it was the Hawaiian asphalt dealer. Remember, there was a minor that went to work for the Hawaiian asphalt company, and the company handbook said that you have to arbitrate everything. This was a bad example of a case to use in here because they held that the child could be bound by arbitration. However, nobody in the company could be bound by it because they didn't make it conspicuous. So that's a terrible example of a case because it was actually upheld for a different reason other than the one they're trying to educate you on. So ordinarily, and I put this in here, that contracts entered into by minors are voidable. says a minor upon reaching the age of majority may choose to either ratify or avoid a contract entered during his or her minority, but it has to be within a reasonable time of reaching the age of majority. I did not put that in, and that was not in your book, but it has to be within a reasonable time of obtaining the age of majority.
Can I ask, does that mean a personal question, but my son has signed up for a ton of these video game subscription things, and he has no idea how to cancel them. Can I just call them and tell them that in this state he's a minor and cancel them so that I can quit trying to get him to figure it out?
You can do that.
Okay,
My son
awesome.
spent $300 on Fortnite last weekend, and we got it back.
Yeah, you can do that?
Fixed.
Been there.
Seriously?
Yeah, like seriously,
Yes.
Google.
It's so easy.
$300 on Fortnite.
All right, who had a hand up over here?
Oh, so you got the money back?
So these I need to go to you about it?
Yeah,
No, they banned him from the PlayStation Network.
that's fine. That way you don't have to worry about next month.
Yeah, I get that.
Yeah.
Look at the exception on there. Goods or services necessary for health or sustenance. Is the Xbox network necessary for your health or sustenance? All right, so if it's a contract for food,
It depends. My son.
if it's contract for food, like baby food, they can enforce that. If it's a contract for a place to live, so that you're not homeless, they can enforce that. Most courts are going to keep going along with the necessaries, is what they call it. And then we had, the contract had to be judicially approved. That's where I introduced you to the concept of a pro-Amy hearing. And that is a hearing on whether or not the court should ratify an agreement. It has to be in the best interest of the child. The minor gets restitution of all payments made, but has to surrender the goods. When I was going through law school, we covered this, and it was a child went to a bike store and bought a bike and wrecked it while they were still under the age of majority. Child took the bike back to the shop and said, "It's wrecked, I don't want it anymore. Give me my money back." Do they get their money back?
Yes.
Every bit of it. And do they surrender the bike? In whatever condition it is, they surrender the bike. And the store had to take it back. Your lesson to learn out of this is don't do contracts with minors. And if you do, then get a parent to sign on as a surety. By the way, my attorney contracts have such a provision on there, it has a surety on the back, just in case the child's a minor. Or in case one of the parties to the contract's a minor. All right. Ortelier versus teacher's retirement. This is where she changed her mind like the week before she died and wanted to get the maximum money today and take all the remainder of her retirement away from her current spouse. And the court came in and said, "Oh, that wasn't a very prudent thing to do. We set that aside because you must have lost your mind." Not in those exact words, but that's the gist of the holding, wasn't it? And they gave the amount of retirement that the husband was supposed to get. They restored that back to him. Section 15. Contracts avoidable if mental defect or illness and you're unable to act in a reasonable manner or the other party knows of the incapacity. So did the insurance company know of the incapacity? Yes, they did. All right, ERISA, the Employment Retirement Income Security Act, that's a federal law passed which takes care of this problem, doesn't it?
Excuse me,
Yes.
was there something about like a lucid period, like if somebody is,
We're actually getting to that. No problem. The Employment Retirement Income Security Act protects spouses from the employee doing something like that. You actually have to have their signature consenting to it.
oh, I see.
Acting during a lucid interval can be the basis for executing a will. However, competence to enter a contract presupposes something more than just a transient surge of lucidity.
So this draws a line between a will and a contract.
It does. And in a contract, you have to understand the effect of what you're doing. the consequences of what you're doing. Versus a will, you just have to have a lucid moment. Kundick versus Broadbent. A contractual act by one claiming to be mentally deficient, but not under guardianship, absent fraud or knowledge of the asserted incapacity by the other party, is not a void act, but at most only voidable at the instance of the deficient party, and then only in accordance with certain equitable terms. Meaning, if the incompetent signs the contract and the seller, assume the incompetent's the buyer, and the seller has no reason to know that they're incompetent, can the seller later get out of it?
Yes.
No, only the buyer. If the buyer's the incompetent, he has the right to avoid it, not the seller. That's the rule. Only the incompetent has the right to avoid. Kenai Chrysler, a valid legal guardianship precludes the formation of a valid contract with the guardian's ward. Restitution only in the absence of actual or constructive knowledge of the incompetency. So, does the dealer get their car back? Yes, unless they knew that the person was incompetent when they signed the contract.
So if they sell a car to me, they know that then the person just gets to keep it.
Yeah. That's what the case holds. Now, the question is this. If you walk into the car dealership wearing an aluminum hat, is there a reason for them to think that something might not be right? Yes, ma'am.
Is there something about if somebody's under guardianship, and it's assumed that you should know this because it's on notice?
The actual or constructive notice. We're coming to that. No problem. You're wanting to hurry up and get out of here. You're trying to watch football?
I'm not. I'm really not. I'm really not.
Oh, I don't remember if I told you about this one or not. I had a client that was in the hospital over at UAB on the 6th floor. And for those of you who do not know about the 6th floor, it is the psych ward. And somebody had filed a petition saying that she was incompetent. So part of the duties as the guardian is to go up and actually talk to them. I went up to the 6th floor, pulled the medical chart, looked, the medication seemed all right, went and talked to her for about an hour and a half. She seemed like she was perfectly competent to me. I explained what was going to happen at the hearing, and she understood and asked relevant questions. Then we go to the hearing the next day, and the funny part is the doctor said, yeah, she's a danger to herself or others because she's not taking her blood pressure medicine. Well, you can die if you don't take the blood pressure medicine, right? So when the doctor said a danger to herself because she's not taking her blood pressure medicine, I said, well, doctor, what is her blood pressure? Doctor spent about 2 minutes flipping through the chart trying to find blood pressure. Couldn't find it and said, I don't know. I said, well, doctor, if you don't know what her blood pressure is, how do you know she's supposed to be taking blood pressure medicine? Now, have I just won that case?
Yep, and then she said something.
At that point in time, the judge turns to my client and says, is there anything you'd like to say?
No.
Now you can see it going downhill very fast. That's where she proceeded to tell the judge that she was the majorette for God. Her brother was Muhammad Ali, and she dated Malcolm X. And she had been anointed to the Alabama Supreme Court. Yes, ma'am?
Talented lady.
Nobody gets anointed. She wasn't delusional. She was making that stuff up. She didn't want to leave. She had a nice place with a bed and 3 hot meals every day.
So she wanted to stay in this segment.
She wanted to stay.
Oh, amen.
So did I just lose that case?
So why she didn't tell you?
Yeah.
So why she didn't tell you?
So here's your question. If somebody starts off by saying they're the majorette for God, do you have reason to believe that they may not be competent? How about if they say they have been anointed to the Alabama Supreme Court?
I just want to put all of this on my list.
All right, overreaching. 3 forms in classical equity of overreaching. That's duress, fraud, misrepresentation, and mistake. That's the intro. So pressure and bargaining, we're getting to duress. Restoration is a proper remedy. It requires a reasonable degree of temerity in the face of a threat. Did y'all look up temerity? Got to have a little bit of fortitude. Y'all know what fortitude is, right? Backbone. I wasn't going to say that. Not that term. But you can't just say, oh, I'm so scared, and then back down. You have to actually hold up to them. And then it's not a threat to threaten to do what it's a legal right to do. If you don't get off my property, I'm going to call the police. Do you have the legal right to do that? Absolutely. So is that a threat? It might be a threat, but it's not an illegal threat, right? All right, so the pre-existing duty rule. Performance of a legal duty owed to the promisor, which is neither doubtful nor subject to honest dispute, is not consideration. So what about the Alaska Packers? Shipped up at the company's expense from San Francisco to catch and process salmon, wasn't it? They decide it's hard work, so they want a pay raise. The company agrees to it, so they go back to work doing the same thing that they had agreed to do to start with. Did they hold that that was a threat to strike, where there was no labor to replace them, by the way? So did the court uphold the increase in pay? No, because you didn't have the right to threaten it. Mutual assent or mutual consent to avoid a contract, or mutual consent to rescind it, I guess. You can rescind and modify, which is the next section. There's section 189 and 2-209. But rescind and modify, it's a 2-step process. Step number 1 is rescind. Step number 2 is modify. That's why they call it that. You can do that as long as the contract is executory, which we've already said is not fully performed. Watkins and Son versus Carrig. Excavating granite, not foreseen in the granite state. Did they have the right to renegotiate something that they should have foreseen?
Yes. No.
They still have the duty to go ahead and do it, right?
Yeah.
So it's not anything else that they were able to get out of. Yielding through a threat. You can't be too wimpy. No feeble threats. You have to overcome. It says you must overcome the mind of a person of ordinary firmness. Well, if you haven't learned this yet, most of the times they call that a reasonable man standard. And then most courts require duress, as it must deprive a person of the exercise of free will. In other words, you're doing what somebody else wants and not really what you want. That's where it deprives you of free will. Avoiding the pre-existing duty rule. If you give them something else, additional consideration, then you can avoid the pre-existing duty, because now it's new consideration, not just what you're supposed to already do. The gift of a horse, a hawk, or a robe, I think, is exactly what they said might be new consideration. All right, partial payments. If you mark the check, payment in full, is it really payment in full? No. The trick to that is, if it's a disputed amount, then it can indicate payment in full. If it's not disputed, which is at the bottom of your previous page, neither doubtful nor subject to honest dispute is not consideration. If it's not doubtful or subject to honest dispute, writing payment in full doesn't take care of it. You still owe the rest.
Going back to that credit collections thing, if somebody decided, if they're demanding $400 and you write them a check for $150, right, paid in full, and they cash it, is it binding?
It depends on whether or not any of it was doubtful or disputed. If it's undisputed that it's $400, doesn't make a difference. You still owe the full $400. Now, if you challenge some of it and then send them a check that says payment in full, and there's still a challenge to the amount, then that would take care of it. You say, I dispute these charges as not being valid on my account, here's payment in full for what I actually do owe, then you may be able to get out of that. Yes? Agreement to testify against another. Remember that guy's plea agreement? He backed out on it and then he went ahead with it. That's the pre-existing duty to a third party, which was the DA. All right, duress in business transactions. Economic duress or business compulsion is still duress, and you can get out of that. The case they gave you was the Navy radar contract. They wanted more money, but they couldn't get their parts from anybody else. Undue influence, Order Easy versus Bloomfield School District, forcing the homosexual school teacher to resign after 40 hours of no sleep, threatening to out him. And he resigns. Huh?
That is not enforceable, his resignation is.
It's not enforceable. The key language out of that is, the key is not the type of relationship, but the nature. A confidential relation is not restricted to any specific association, but is deemed to exist whenever a relative position of the parties is such that one has power and means, you got to have the two things, power and means, to take advantage of or exert undue influence over the other. You got to have the power to do it, and then you got to have the means to do it. Concealment and misrepresentation. There was a term in there called dictum. We explained what that was as compared to ratio. There's a typo in there. It's got an N on it. You need to scribble through the N. Ratio decidendi, and that is the rationale for the decision. If it's not part of the rationale, it's dictum. And it's non-binding if it's dictum. So, Swinton v. Whitensville Savings Bank. That's the sale of the home with the termites. By the way, this is bad law, and it's been overcome by federal law that says you have to give a termite notice on every land sale, right? So, the law has come back and fixed this problem, but the case still stands for the proposition that if you have a bare non-disclosure, you just don't say anything about it, then you have no liability. That's the principle that it gives you, is you're not liable if you just don't say anything. So then it gets into these things called latent defects. It's a deleterious condition known to the seller but not readily discoverable. So, are termite infestations readily discoverable?
2 years.
Well, not really. It depends on how long they've been there.
Have any of you guys actually seen a termite guy come out and inspect your property?
Yes.
What do you think they do to determine whether or not your wood's got any termites in it? They take a screwdriver and press it up against the wall, and if it goes in, you got termites. Is that readily discoverable? Nobody goes in and presses screwdrivers up against the wall. Yeah, first of all, you don't want to damage the property, do you?
No.
So it is a latent defect, and you're supposed to tell them if you know about it.
What about the mounds and the blind termite? Do you see that? Those are good too.
The mounds in the backyard?
Yeah.
Well, if you see termite mounds, can you tell the difference between that and ants?
No.
Now, how many of you have actually seen a termite nest? How many of you have actually been to Mexico? Those are the ones who've seen the termite nests, right? They're these big things that look like hornet nests up in the trees. Those are termites. Now, if you go out in the backyard and see a termite nest, and you don't see hornets or anything flying around, you got a pretty good idea that there may be a lot of termites. Canavos versus Anino. That was the single-family dwelling that they turned into apartments. What was the latent defect on that? It was zoning, wasn't it? That's one you'd never expect to see, that it actually violated zoning laws to have an apartment building when it was zoned strictly for single-family dwelling. All right. They said retyping a contract to look like the original but with changed terms. Remember the guy that did that?
Yes.
Court called that a scheme.
I call it smart.
A no reliance clause, the court called the big boy clause. I'm not relying on anything that you've told me about this property. The only thing I'm looking at is the four corners of this contract. That's a no reliance clause, and that's what they pay the big bucks for to the lawyers.
Where do home inspections work into this?
Huh?
Where do home inspections come into these kinds of scenarios?
Well, that's your reasonable opportunity to inspect the property for latent defects. If you don't find any, then there may not be any to tell you about. But most home inspectors I know limit the amount that you can recover just to whatever you paid for the home inspection.
So like $400.
$400 is all you get for $50,000 worth of termite damage. That's why you get a termite bond. All right, fraud and misrepresentation. Scienter. Either you know that it's false or it's reckless disregard on whether or not it's true or not. That's what scienter is. A misrepresentation of law is innocuous, meaning it's harmless, unless it's a lawyer or an insurance agent telling you what the law is. Then it's not innocuous, right? They say some degree of diligence is required. You have to have justifiable reliance, not mere reliance. So what's justifiable?
Being a million on something.
Well,
It was a reasonable.
how about this? You're going to buy a house. Many of you own houses, so you're going to buy a house. Would you buy a house without having title insurance? Some people might buy a house without title insurance, but would you buy a house without even going down and looking to see whether or not the person owns it? That's the difference. Justifiable is if you've actually gone down and actually looked. Mere reliance is, oh, you want to sell me the Brooklyn Bridge? Okay, I'll buy it. Did they have the right to sell it? You don't have justifiable reliance. Is the court going to give you relief in that case? Probably not. A representation as to the legal effect of a document is regarded as a statement of opinion rather than a fact, and will not ordinarily support an action for fraud. It must be fraud as to a fact, not an opinion. Remember, the exceptions are lawyers and insurance agents. If I give you an opinion on whether or not it's a good contract, it's not just an opinion, it rises to the level of a fact because of expertise. Same thing for an insurance agent. Now, on a related note, you know what the difference between slander and non-slander is?
One's true and one's not.
Yeah, the slander is where you say something bad about somebody as a fact, right? But if you don't represent it as a fact, it's not slander. I think he's a crook. Is that slander?
No, because that's your opinion.
It's my opinion. He's a crook.
Slander.
That's slander, right? So there's the opinions don't get you in trouble. Stating facts too.
But then where does it come in where it opinions can become facts?
If it's by a lawyer or an insurance agent, the insurance agent says, I think this policy will cover you in the case of any losses you have, then the fact that they think it'll cover you is not an opinion anymore because they're trained in insurance policies. Then that would become a fact that you can rely on. Remember the mineral oil problem? I think this ought to lubricate that machine pretty good. He was the expert, right? So what they're looking at is whether or not the person's an expert. If the doctor says you're not going to die from this, and then you die, what happens? You don't know you're dead, right? Your family has a right to sue for something. Promissory fraud. Y'all talked about promissory estoppel. Promissory fraud is at the time of making the contract, you had no intention of performing. You're just telling somebody to get somebody to do something. Note also that not only do you get compensatory damages, but here's the exception for punitive. If it's fraud, you get punitive damages. Everywhere else in contracts, you don't. But where it's promissory fraud, you do get punitives. 2-609, I think, addresses that from the UCC. All right, speakers of sport versus pro-serve. It's one sports agent steals the athlete from another sports agent. Is that actionable? Oh, I'm going to get you $2 million worth of endorsements. What is the promise of getting you $2 million worth of endorsements? They had a term for that, didn't they? It's puffing. It's a sales pitch to try to convince you to do something, but it's not a guarantee. They actually do say that a binding promise of something over which you have no control, that's called a warranty. Do you have control over whether or not companies are going to sign endorsements with you? That's why they say it's not binding. That's puffing. Competition is not a tort. Tell that to all the mom and pop grocery stores that Walmart's put out of business. All right, Vokes versus Arthur Murray. Oh, you are so good at dancing. Let's buy some more lessons. Was that mere puffing, or is that from somebody who should be quasi-expert? Quasi-expert, does she have the right to rely on?
Yep.
Now, what if she actually danced in front of a mirror? And she had good reason to know that she was no good. Huh?
Would go back to the big boy rule that you should know better.
Yeah, maybe they told her it was a dramatic improvisation. All right, chapter 5.
Excuse me.
Yes, ma'am.
So I'm going to get you $2 million in contracts. You have no control over it, so that's puffing. But a warranty is different because you should know what the product is.
No,
You said the warranty part of it.
if you make a product and then you don't have control over whether or not it's going to fail, then that's a warranty. That you're going to replace the product. But the puffing is to, I'll get you $2 million worth of endorsements. Had they said, I guarantee you to get you $2 million worth of endorsements, and they don't get it, but then they still have to pay up, that would have been a warranty. So puffing is, without guaranteeing, is going to be just puffing rather than a warranty. All right, chapter 5, the party's obligations under a contract. We're almost done. We're just going to get into chapter 6. Parole evidence includes oral agreements, also operates to exclude writing such as letters and emails. The difference is going to be whether or not it's been integrated or not integrated. Fully integrated or partially.
Exclude those?
It's what?
It says it will exclude writings or include?
Exclude if they're contrary to the writing. See this intro part?
Okay.
The intros on every one of these chapters is terrible until they get into the meat of it.
Right.
They just tell you what they're about to get into. All right, your two considerations that they say you need to have is you have to raise it or waive it. That was my words. Their actual thing was you have to raise timely objections in our advertorial system, or otherwise if you don't raise your timely objection, it's going to be waived. And then the second one is the Erie Doctrine. where they said that the law of the state, if you're in federal court, the law of the state controlling the contract is going to apply. That was the crazy case out of California, right? Where the Ninth Circuit overturned the U.S. District Court because California's rule on parole evidence controlled. That's in a minute.
Professor, what page are you on, page 49?
Where?
Yeah, what page, please?
406,
406.
chapter 5, and then section 1 is 406. Gianni versus R. Russell, that's your soft drink store case, where they tried to say that they had exclusive rights to sell soft drinks in the building, but did they include the exclusive rights in the contract? And the contract included things about soft drinks, but it didn't say that it was exclusive. So did the court allow them to introduce their oral testimony that, oh yeah, it was supposed to be exclusive?
Or no, because it was in writing.
The answer is no, because the writing addressed the issue, and they were trying to introduce extrinsic evidence, which would have been oral testimony, which contradicted the contract. Contradicted because it was something about the same subject, but it was different than what was in the contract.
So it was parole that was excluded.
It was excluded because it was,
addressed in an integrated matter.
yes,
How do you phrase that using the word parole evidence?
the way she said it.
She didn't say parole evidence.
Yeah, the parole evidence was excluded because it was contrary to a term of a written contract.
I didn't hear that.
Section 213 of your restatements, and then integrated agreements is 209 and 210. Completely integrated means no terms to supplement. All the terms that you want included in your contract are there. That's completely integrated or fully integrated. Partially integrated contracts may be supplemented with consistent additional terms. Not inconsistent, but it has to be consistent. So Masterson versus Sign, selling your home with a buyback clause. Remember the guy that only just wanted a loan, but his brother wouldn't do it? So he agreed to sell him the house, but he had the right to buy it back. What was the clause in there that they wanted to include parole evidence, and the court actually allowed it?
That it was an exclusive buyback clause, not just open to the...
What was that they wanted to keep it in the family, right? Everybody understood you wanted to keep it in the family, and that was not inconsistent, and it was not a fully integrated contract. So they allowed it in. Merger clause. That's also called an integration or an entire agreement clause. The example they gave you in the book is there are no promises, verbal understandings, agreements of any kind pertaining to this contract other than specified herein. And if you wanted to be fancy, you could say within the four corners of this contract. It means the same thing, integrated herein. So for the test for contemporaneous oral agreement to be admissible, it must be collateral. This is a contemporaneous oral agreement. Remember what this is? I didn't put it in your handout. We talked about it in class. How many contracts are there? 2. This is a collateral agreement. It's not the first agreement. It's a collateral agreement. So there's 2 contracts. Can the 2 contracts be inconsistent with each other? It has to be collateral. It has to be about something else. That's the first.
Totally unrelated to what's in the original.
Not totally,
Or like
but not something that you've already agreed to. It's an additional agreement.
Okay.
So it can't contradict.
That's number 2. Must not contradict express or implied terms. And then number 3 is be something that you would not ordinarily be expected to put in your first writing. So those are automatically admissible.
So it'd be
Bollinger?
like something that just came up later, like you just didn't expect, and you can go back and add it.
Yep. And that would be a collateral agreement.
Can you have a collateral agreement where the parties agree that in the future they're going to change the terms or add to?
such as no changes to our contract unless they're in writing?
Oh. Okay. You can.
And you can't, because that provision can be changed by agreeing you're not going to abide by it. All right, so Bollinger, Court of Equity has the power to reform written evidence of a contract and make it correspond to the answering of the parties, or the agreement of the parties. The mistake must be mutual. The fact that one party denies that a mistake was made does not prevent the court from finding a mutual mistake. Remember what this case was? I want to use your land to bury my garbage. I will cover it up with dirt. And then they stopped covering it up with dirt. Didn't the court find that that should have been their original agreement, that term should have been in the contract, since it had been negotiated? And that's exactly what the court did. Parole evidence for the sale of goods, that's 2-202. And you know oral modifications is page 419, traditionally ineffective. And then they mentioned private statute of frauds. If you want to put down these are the circumstances and make an agreement that says these are the circumstances where we have to have a writing, you can do that. But it's not the law on the statute of frauds, which is on the book for everybody. You'd be creating a private one. All right, the use of extrinsic evidence on the party's intent. This is where they introduce you to something called the plain meaning rule and statutory construction. So when do you get to use judicial construction of your contract? Here's where it says the two-part test. The judge determines whether the language, with respect to the dispute in question, so it has to be relevant, admits of only one plausible meaning or is ambiguous. If it's not ambiguous, extrinsic evidence of its meaning will be excluded. If it's not ambiguous, you cannot introduce any evidence to explain what you meant.
It's not ambiguous, wouldn't it be unnecessary to bring up?
That's what the rule is. And that's the plain meaning of the words. If it's not ambiguous, you go with the plain meaning and you don't introduce extra evidence. Parole evidence. However, if it is ambiguous, extrinsic evidence as to its meaning will be admitted to inform the court, to inform their determination of what the contract actually meant.
So you can have parole evidence in the second case?
If it's ambiguous, you can admit parole evidence to explain what the parties truly agreed to. But if it's not ambiguous and it's clear, then no parole evidence at all. All right, so Pacific Gas, the indemnity clause for the damage to the exposed rotor of your turbine. Remember that case? They included the actual turbine owner and not just third parties for indemnity. So when they damaged the turbine, did the defendant have to pay to repair the turbine? Yes, they did. Because they had signed an indemnity agreement that says we will protect you from any losses.
And then they were able to show that that was standard.
Yeah, even though it was not standard language, they had got them to agree to it. So they had to pay for the repair. Delta Dynamics, the trigger locks case, that was a minimum orders. We guarantee you that we'll buy 10,000 of these the first year and 20,000 each later year. If they don't buy 10,000 the first year, is there a breach? Yeah, there's a breach. What about market changes? Doesn't matter, they still agreed to buy the original quantity. Greenfield versus Phyllis Records, the Ronettes royalties on movies and third-party licensing. When they gave them all rights to those recordings, even though there was no such thing as whatever that term was when they used soundtracks for movies, synchronization. Did it matter? No, because they gave them all rights. However, remember also that that was just on the original recordings. What about new performances after the contract expired?
They weren't addressed.
They were not addressed. So they ended up getting $2 million out of that. WWW Associates. You can't use parole evidence to create an ambiguity. The ambiguity has to be there to start with. Hey, got to give it to those lawyers. They tried an angle. And the court said no. Here's Trident Center versus Connecticut General Life Insurance. This is the lawyers out in California that wanted to build an office building. And they wanted to introduce parole evidence for something that was not ambiguous. The federal court in California said, no, you can't do that. But the Ninth Circuit said, yeah, under the Erie Doctrine, when it's a state law issue, you have to apply the state law. And since California's got this crazy law which doesn't follow the rest of the country, you still have to apply Florida or California law. And under California law, they have the right to introduce that evidence. So methods of interpreting ambiguous contracts. Page 433 for those of you keeping up. What color is green, or what shade is it?
We don't know.
Yeah, it depends, right? Y'all seen that commercial for Ireland tourism about having 1,000,000 shades of green? Punctuation. Remember we talked about farm and implements. And if I put farm implements without a comma, you don't get the farm. But if I put a comma, you get the farm and the implements. And then they give you the statutory analogy, the purpose interpretation. What was the reason for passing the law? Well, the analogy to that is, what's the purpose of the contract? Lord Escher's 3 rules, that's something that just to me looks like it might be bar material. Remember, there's 2 parts of a contract. There's a recital and then there's the operative part. The recital is, whereas the parties were married on such and such a date, and whereas they want to separate and get a divorce, and whereas they want to take care of all their property disputes now and forever, wherefore they enter into the following agreement. Number 1, husband and wife shall be divorced. Number 2, who gets the house? Number 2, who gets the credit card debts? So your whereas are your recitals, your wherefore they enter into the following agreement, those are the operative part. So where the recitals are clear, the operative part is ambiguous, the recitals govern the construction. And if the recitals say we want to resolve all property disputes between the parties, and there's an ambiguity as to whether or not there's an unsettled property part, what controls? The recitals. So what does that mean? Doesn't matter if you left something out. The recitals say it takes care of everything. That's the best example I can give you of that.
Is that going to be on the test? Probably now. It will be, but
I'll try to find something for that.
Ask on that. I probably need to.
Okay, so if the recitals are ambiguous, but the operative part is not, then the operative part controls, right?
Because it tells you what to do.
So what if both the operative and the recitals are clear, but they're inconsistent with each other? Then the operative controls.
Could you explain again the recitals, what that means?
So 1 and 3.
Whereas the parties have been married, whereas now they want a divorce, whereas they want to take care of all their disputes now and forever.
It sort of lays it out.
That's the
then
recitals.
operative part.
And
What
then the
you gotta
operative-
do about it.
Yes.
Okay.
If both are ambiguous,
The recital is really long.
If both are ambiguous, then do you have an agreement? All right, so public interest can be a reason why a contract's not good anymore, or never good. The restraint of trade and the restriction on the use of land is against public interest. Ooh, that's a foreshadowing of a case. Maxims, contra proferentum. Profferentum is a profferer, right? Contra means against. Contracts are interpreted against the one offering it, and they're the ones that have usually drafted it up. So it's against the drafter. Juries handle questions of fact, except in bench trials. Judges handle questions of law. Oh, I missed one. If you draft a contract as an attorney, it's always going to be construed against you. Not only are you the one that drafted it, but you're a lawyer. You should know better. You're trained on how to use language, so you're expected to know exactly what you said. All right, Section 3, the extrinsic evidence. From a commercial context, if you say that you're going to sell USDA chickens, USDA grade A chickens, what exactly are you agreeing to?
To sell grade A chickens.
Yeah, so are you going to necessarily comply with what the USDA says is grade A?
You're going to have to if that's what you say yourself.
You've just incorporated the standard by reference. And, well, you're incorporating a standard by reference. If you reference a standard of grade A, then you're saying that becomes part of the contract. So what this section is about the commercial context, if you have a standard from outside and you reference it in your contract, then you're incorporating that standard by reference.
So don't fuss.
Incorporation by reference also means that it's the law at the time that you make the contract. So the guy who wanted to get out of paying child support at age 18, the age of majority, several years after he entered into the contract, where the age of majority at the time of the contract was 21, he was held to have to pay it till 21 because that standard was incorporated at the time he made the agreement. All right, Hurst versus W.J. Lake. We're going to sell horse meat. And it's going to be 50% protein, right? So what is 50%? Is that 49.5 and higher? Or is that 50.0 and higher?
You have to clarify that.
What it boiled down to was the usage in the trade, didn't it? The usage in the trade was 49.5 or higher was considered to be 50. And that's a commercial context again. It's the trade is commercial. Extrinsic evidence to support or to supplement or qualify the agreement. Course of dealing, usage of trade, and course of performance. UCC 1-303. And then Hawaiian asphalt. Use of the trade is only binding on members of the trade or persons who know or should know about it. Well, if you pave with asphalt, are you an asphalt seller by trade?
Yep.
If you pave with it
If you
only?
paved, if you buy the asphalt from somebody and pave, are you an asphalt seller by trade?
You're not a seller, you're a paver.
You're not a seller, you're a paver. But should you be familiar with the terms of asphalt sellers?
Yes.
Yes, because you buy a whole lot of it, right? So it doesn't necessarily mean you have to be a merchant in that same field. But if you're aware of it, then you're going to be bound by the standard. And then the best quote out of that case is, course of dealings is more important than usage of the trade, being specific usages between the two parties to the contract. So if they've price protected you 2 times before in the past in your course of dealings, and now they want to go up on price on you and not protect you on the price, what's going to control?
Your past dealings.
Does it matter what the usage of the trade is if you've got past dealings? No, because past dealings are going to control.
But how many past dealings do you need? Like more than one?
It looked like they got away with 2 of them in this case.
That doesn't seem like a lot.
I would say it's probably not enough to establish a pattern, but it's enough to establish dealings, being 2 or more.
I would think it's enough to make me expect it.
And that's what the court held, so I would agree with that.
If leadership in a company changes, it's the same company, but you have a whole new leadership. Does that course of dealing carry over to the new leadership, or maybe they do things differently?
Let me answer your question this way. If new leadership takes over and doesn't put you on notice that things are about to change,
Then you assume.
then you have a course of dealings, right? But if you put them on notice where they know or should have known, then I think it takes it out of that exception. Motion in limine. Remember what that is? It's a pretrial motion, so you don't have to argue on something in front of the jury. It can be just about anything. It can be on whether or not certain expert testimony is going to be admissible. Remember we talked about Fry and Daubert, Fry standard and Daubert standard? And if you have a hearing in advance to determine whether or not your expert's going to be allowed to testify, that's done outside the presence of the jury, so that when it comes time for the jury trial, you don't have to raise that again because the judge has already ruled on it. Then you can go ahead and present your testimony. Other example I gave you is illegally seized evidence. You might want to file a motion in limine to keep it from being introduced at trial. If the court says that evidence is not admissible, what happens to the prosecution's case? No, not a mistrial.
If they try to bring it up.
If they bring it up when they're not supposed to, that would be a mistrial. But when they know that they can't do it and they don't try, what happens?
They lost their right.
Settle?
All right, let me give you an example. What if I've got a police officer who stops a car for no reason? And in the car they happen to find a weapon. Now I file a motion in limine to prohibit the introduction of the weapon, and the judge agrees, yeah, it was an illegal stop, you can't introduce the weapon. So now we're at trial for carrying a concealed weapon. However, they can't introduce any evidence whatsoever about the weapon. Prosecution's probably going to dismiss it because they don't have a case. That's the ultimate outcome if you get evidence excluded. They should. If they don't, they go to trial, you need to be on your toes about them trying to mention anything about the weapon, because if they do, then you ask for your mistrial. Yeah, that's for your criminal procedure class, but yes, you can't use fruits of the poisonous tree. Columbia, nitrogen, the fertilizer manufacturer wanted to sell phosphate with a minimum contract, but it was a declining market, and they didn't buy the minimum amount of phosphorus or phosphate. Was that a breach? Yeah. Objective interpretations and its limits. Raffles versus Wickelhaus. I want to buy the cotton that's coming over on the Peerless. Is that a good contract?
No.
It looks like one up front, doesn't it?
Yeah.
But what if there's two Peerlesses and both of them are carrying cotton? It's ambiguous, isn't it? But you don't know that till you get in on it. Section 20 of restatement. All right, how about Colfax envelope versus the union, where they agreed that so many people had to run these particular press machines that make envelopes? Okay, the bottom line on that case is that the union sent over, every year before, they sent over the entire negotiated agreement, and the manufacturer of the envelopes would sign it and send it back and be bound by it. Except this time, instead of sending the entire agreement, they sent over a summary which did not include an arbitration clause. So the manufacturer signed the summary, which did not include arbitration, and sent it back to the union. And then they wanted to enforce arbitration. Was arbitration part of the summary? Did the manufacturer agree to be bound by it? Not on this one. So just because you sign the summary doesn't mean you agree to all the terms.
Is that because of course of dealing?
They had never sent over a summary before. So was it course of dealing if they sent over something that they've never done before?
That was what they did.
Because they always sent over a full contract,
But this time they sent over a summary.
which didn't have the opportunity.
Right, so was the manufacturer entitled to rely on the fact that this was the whole agreement with the course of dealing that they'd always sent it over before? Yes.
That's what I meant.
Okay, looking from it from his side rather than the other. All right, filling contractual gaps. Implied in fact terms, the court's finding as to actual expectations of the parties. They can imply facts. However, implied at law means that the court's going to supply things by a rule of law rather than the facts and circumstances of the parties. They have 2-308 and 310, which is your off-the-rack default terms. You need to know what those terms are. That if the parties don't agree to a certain term as to price, what do you think the term is going to be implied by law on?
Fair market value.
Oh, come on, somebody has actually read 308 and 310, haven't you? You know what the court implies the term to be? The price at the time of delivery, right? If the open term is price, it's price at the time of delivery. They introduce implied warranties. They start off with the old Latin phrase, caveat emptor. Let the buyer beware. So what is an implied warranty of merchantability?
It means that it's good for what they intend it to be used for.
That's a particular purpose. Merchantability means it's, number one, it's a fair average quality. Does it have to be the highest quality? No, it's just got to be fair and average. And then number two, it's fit for an ordinary purpose for which the goods are to be used. For which they're ordinarily used. The ordinary purpose for which the goods are used. So the case was our fire blanket. Was the fire blanket, which is rated to 800 degrees, supposed to be used to stop welding over 1,000 degrees? No, you can't expect it to be used outside of its ordinary expected uses. The question is not subjective expectations of the particular use, but the reasonable expectations of an ordinary user or purchaser of that product. Because on the next page it is fitness for a particular purpose. UCC 2-315 spells out all the circumstances for a particular purpose. Lewis versus Mobil Oil. It's where he put mineral oil to lubricate the lumber mill, and it foamed up. And it caused the machine to overheat and cut off because they didn't have what included in the oil? An anti-foaming agent, right? Now, in this particular case, he said, I don't know what kind of oil I need. You tell me and you supply it, and I'll just go with whatever you give me. The important part of that is the seller has to have a reason to know of the use of the goods. The oil seller, does he have a reason to know what the use is? Yeah, I want oil for this machine that I'm going to use for lumber. So he goes and looks at the lumber machine and says, oh, this is the kind of oil you need. And the second one is they rely on the seller's expertise in supplying the proper product. Now, had he come out with mineral oil and the guy looks at it and says, are you kidding me? I could have bought that at CVS. Are you sure that's the right thing?
But it had mobile on it.
Yeah, he relied on it, period. Excluding warranties and the implied warranties, 2-316, but look at South Carolina Electric and Gas. They disclaimed warranties without using the word merchantability. Well, under the UCC, doesn't it say that if you're going to exclude the warranty of merchantability, you need to say merchantability? It's exactly what it says. And because they did not use the word merchantability, it was an ineffective waiver of the warranty of merchantability. And then remember, they also put a misleading title that says warranty. And then when you read it, it says no warranty. They found that to be misleading. And then the last thing they said is disclaimers must be conspicuous. Can't be in the same type, has to be different. Font, format, or something else, or bigger. You got to make it stand out in order for it to be draw to their attention. Notice also that warranties, implied warranties, are not implied when the buyer has inspected the goods before entering into the contract.
What does inspected really mean? How deep do you have to get into?
Well, the case that they gave was the gaskets, the rubber gaskets. They tested them, but they didn't test them for what they were particularly using them for, but only whether or not they met specifications. And they said that that was enough, that you had the opportunity to inspect before you bought it, that there's no warranty on that. New car warranties. Under page 482. Remember, they tried to say that there's no warranty on this vehicle. However, the standard contract drafted by the attorneys, which every car dealership used, which disclaimed warranties, did they have the opportunity to negotiate that? They did not. And since they said it wasn't an arm's length negotiation, fair and open to both sides, that they weren't going to bind them to it. And then after that case, of course, is the Magnuson-Moss Warranty Act that says, oh, by the way, as a matter of federal law, you cannot write out warranties in your sales contracts for cars. So now you don't see them doing that anymore. Express warranties, UCC 2-313. They actually point out that there's 3 ways to create it. Number 1, it's if you make an affirmation of fact or promise by the seller with respect to the goods, that creates a warranty that the goods will conform to that affirmation or promise. All right, so let's say that you go into a car dealer, tires. You say, I want to buy a set of tires that's going to last me for 50,000 miles. Oh, these will last you for 50,000 miles. So you buy them. Is there a warranty there that they should last you for 50,000 miles?
No.
They made an affirmation that these will last you for 50,000 miles. It's an implied warranty that they will last for 50,000 miles.
And isn't it also implied like you'll drive reasonably and on this type of terrain? Like,
No, that's why you buy the road hazard. That way you cover anything else that happens to the tire. Just so that y'all know tires are rated for different speeds, right?
Yeah.
You've got your T ratings, your U ratings, your H ratings.
Race car rating.
I've actually seen a judge in court where somebody was speeding, going over 100 miles an hour on the interstate, and the judge asked the defendant, what speed were your tires rated for? He was trying to get to the defendant whether or not he was being reckless by driving the cars in I think it was a motorcycle, in excess of the speed for which his tires are rated. What happens if you drive faster than what the tires are rated for?
no blow.
You have a risk of a blowout. What happens with a blowout?
You wreck and you can't control the vehicle.
And what can you do? You can run into a whole bunch of other cars, right? Or kill yourself. So car tires being rated for certain speeds, and then tires to last for a certain amount of miles.
What would that be? Would that be negligent? If you don't know it and you go 100 miles and you blow out and hit cars?
I would probably argue that it's wantonness, reckless disregard as to what happens to others. All right, the next one is a description of goods creates a warranty that they will confirm to the description. Now, how many of you have seen that thing on Facebook floating around with instructions on children's clothes? Remove children before washing.
It feels like half the stuff online in here.
That means somebody.
It is half the stuff.
Yeah.
The reason why these warnings appear on labels is because lawyers have actually had to sue for that reason.
Good Lord, but you didn't tell me to take my child out?
Yeah. The last one is you provide a sample or a model of the goods. It creates a warranty that the whole of the goods will conform to the sample or the model. All right, supplementing a contract with mandatory terms, good faith. That's the only one, and the only one we're covering is unfair terms, because the rest of the stuff's for next semester. So unfair terms of good faith, well, good faith number one. UCC 304 and 205, Section 205 of restatement. Now Chapter 6, unfair terms. There were a few cases. The first one was McKinnon versus Benedict. That's the campground sale that says they can only do certain things with the land. And that court found it was an unfair term, but their language says that the consideration was so gross as to be unconscionable. Unconscionability of a contract is a different reason to get out. This is unfairness. Tuckweiler promised to care for a family member for the rest of their life, and they die the next day after you've quit your job and have already cared for them, showing the kind of care that you're going to provide, and you agree to provide that same level of care, even though they get a fortune back because they died real soon. They didn't know how long the person was going to live, right? So what they promised to do of indefinite duration and indefinite unknown and uncertain duration, does that make sure that the consideration in that case was fair? It's what you promise, it's not what you actually have to deliver. Remember, hindsight's 20/20? Yeah, if I knew it was only going to be for a day, I promise you that. But what they promised is actually much longer term. Intro to Black Industries. That's the middleman contract for anvils, holder primers, and plunger supports, whatever those are. But this guy was trying to say that the contract was unfair because this middleman had a certain level of markup. He was buying anvils at one price and turning around and selling them for 6 times that, 600% markup. And the guy was saying, oh, that's unfair and it's illegal because you're selling it to the federal government at that price. Of course, they said no, that to declare a contract void against public policy, it must be invalid on the basis of a recognized legal principle, such as paying someone to induce a public official to act in a certain manner. All right, what's that called? Bribery.
Sorry.
A contract to do an illegal act. Those are hit contracts, right? And then a contract that contemplates collusive bidding on a public contract. That's illegal too. I'll bid this much if you bid this much. That's collusive. Intermediaries, it says they perform informational search functions. They're a valuable part of the free market. And they also perform the function of shifting risk, or risk shifting. Remember we talked about that being commodities brokers? They buy a certain amount of corn that if the corn doesn't get produced, they're out of luck. If it does get produced, they guarantee a certain minimum price. And then they turn around and provide it to others. They're that intermediary. Fairness, excessive profits, and government contracts, they talk about the Competition and Contracting Act of 1984, which does require full and open bidding unless it's an emergency basis like Hurricane Katrina for roofing supplies and other things. That's the exception to it. Federal acquisition regulation you were introduced to, that's just the way the government says that we have to do business, our contracts. And then cost reimbursement contracts is one of those. And then the False Claims Act, where you overcharge the government for something. If you intentionally overcharge them, then whoever is the whistleblower, by the way, that's the whistleblower case, if you don't have it in your notes. Folks, that winds up the full semester of contracts. We'll pick up on page 502 next semester. Again, it's probably going to be multiple choice, probably about 30 of them. And one essay. Remember to use IRAC when you write your essay, so you can show off your legal writing prowess.
It's time, right?
Yeah, you'll get the same amount of time on your multiple choice that you get for bar exam questions, and same time on your essay. I know essays usually 30 minutes per question, and it's either 120 or 130 or 140 per question. I'll go back and refigure that. It's 9 o'clock, 2 weeks from today. 9 o'clock. 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 9